Good afternoon, this is Sean Golding with Golding & Golding. As we enter another tax season, a common question we will get here is whether green card holders or permanent residents are required to file tax returns and pay U.S. taxes. Typically, the answer is going to be yes. Sometimes there may be some exceptions, so let's jump into it. First thing to remember is the United States is different than most other countries, unfortunately, the way it taxes individuals, which is that it taxes you based on your U.S. person status. So essentially, if you're a U.S. citizen, a lawful permanent resident, or foreign national who meets the substantial presence test, you have to file U.S. taxes and pay taxes on your worldwide income. For green card holders especially, it's important to note that there's no actual residence requirement as in living in the United States. You don't have to meet the substantial presence test in order to be taxed on your worldwide income when you're a green card holder. That's for visa holders like H-1B, L-1, B1, B2, things like that. Sometimes, depending if the taxpayer is a green card holder and lives in a treaty country and makes an 8833 election to be treated as a non-resident alien for tax purposes, they may be able to be taxed only on their U.S. sourced income, not their worldwide income, but there's various requirements that you have to meet, and living in the United States full-time or primarily full-time is most likely going to negate that opportunity. So a few things that permanent residents need to know about taxes. First, as we mentioned, you pay tax on your worldwide income. So whether that income is earned in the United States or it's earned overseas, whether it's considered U.S. sourced or foreign sourced, whether the green card holder lives in the United States or lives abroad, all of the income from a baseline perspective is taxable. Even if that income is taxed overseas or it's exempt overseas, you still have to include it on your tax return. Now, if there's an exception, an exclusion, or a limitation, then maybe you can avoid having to pay tax on it. If you're living overseas and you meet the foreign earned income exclusion, remember you still have to file, but you can file a Form 2555 and exclude upwards of $130,000 of earned income, as well as the housing exclusion. If you have foreign tax credits, which means you paid foreign taxes on the foreign income, you may qualify to apply those foreign tax credits to reduce or eliminate your U.S. tax liability on that foreign income. If you have leftover, you may be able to carry it forward into future years to offset foreign income. You can't use it against U.S. income liability, but you can use it against foreign income tax liability. A few key facts that green card holders should be aware of, we see often here, is first, just letting your green card expire is not the same as terminating it. So if you let your green card expire, technically you're still considered a U.S. person for tax purposes. The U.S. person for tax purposes status doesn't disappear just because the green card expires. Instead, you have to proactively terminate your status. Typically, that's going to be filing an I-407, depending on whether you're a long-term resident or not, whether you'll be considered covered, subject to exit tax is something to consider before filing that form. A lot of times taxpayers may have a green card but then go back overseas and have a reentry permit, which means they don't have to meet the 6-month requirement. Typically, it's 1 to 2 years at a time. That is an immigration status. That's not a tax implication. So in other words, even if you have a reentry permit and that reentry permit says, hey, you don't have to come to the United States, this year or next year, you're still considered a U.S. person for tax purposes. And with everything that's going on now, even if you're not allowed back in the United States, technically, if you're considered a green card holder, you're still subject to tax on your worldwide income and you still have to file. So if you're out of compliance and you want to get into compliance, there's various options available to you. If you're willful, there's a voluntary disclosure program. If you're non-willful, there's programs such as the streamlined procedures, delinquency procedures, and reasonable cause available. We have a ton of free information available on our main website and our sub-websites. You can always reach out and schedule a reduced fee initial consultation if it's appropriate to your matter, and it's something that we handle here. Again, my name is Sean Golding with Golding & Golding. Thank you for your time. Enjoy the rest of your day.